Hello, everyone, and welcome to my presentation on the UNIDROIT project on digital assets and private law. I'd like to start by thanking the Hague Conference on Private International Law for their kind invitation to me and to UNIDROIT to their CODIFI conference to present this project. Very happy to be joining the Hague Conference, which is one of our sister organizations, for this excellent conference, and we look forward to collaborating and working with them on other initiatives in the future. The UNIDROIT Digital Assets Project is one of our flagship projects right now and looks towards providing a set of principles that look at private law issues in digital assets. Over the course of the next 20 minutes or so, I will be going through the background of the project, talking about the different sections that the principles presently have, as well as examining some of the future work that is coming up with regard to this project. So without further ado, let's get into it. The UNIDROIT Digital Assets Project started as a proposal that was received at UNIDROIT from the Czech Republic and Hungary in 2020 for work in the area of the digital economy, with a particular focus on several different types of things, including digital assets, artificial intelligence, smart contracts, and other related topics. Following this request, the UNIDROIT Governing Council decided to establish an exploratory working group to further iron out the specific areas that UNIDROIT could explore. And at the end of these deliberations, came to the conclusion that the best area that the UNIDROIT was most suited to develop an instrument in was that of digital assets and private law. As such, since 2020, a working group was established, and between 2020 to 2022, the working group has met 6 times, with the most recent meeting of the working group taking place in Rome only a couple of weeks ago. The project on digital assets was incredibly interesting for UNIDROIT's member states and all of UNIDROIT stakeholders. Given this, it was decided to establish a steering committee composed of UNIDROIT member states to act as a sounding board for the project and for the working group. As such, following an official mandate to do so, a steering committee was established and has been consulted once, and presently has more than 20 member states of UNIDROIT as its members. Additionally, the working group also established subgroups for various work streams, including things such as custody, control, transfer, and conflicts of laws, to do specific work in specific areas. There have also been 9 sessions of a drafting committee, which is in charge of putting the principles together. The key idea behind the work of the UNIDROIT Working Group on Digital Assets and Private Law is to develop a set of draft principles that embody best practices and international standards for issues relating to digital assets and private law. These issues include things such as the holding of digital assets, the transfer of digital assets between parties, as well as the use of digital assets across a variety of commercial use cases. There is also the intention to develop an annex to the principles that will serve as a legal taxonomy relating to digital assets. Additionally, the principles have a commentary which details their use and application, as well as points to examples and offers guidance to states and to legislators on how to implement these principles domestically. It's important to state that these are private law principles and deal strictly with private law matters relating to digital assets without touching upon regulation or issues of public international law. Finally, almost since the beginning of the project, it was considered very important to take a functional approach and an iterative approach so as to make sure that the principles are future-proof and are not impacted by new developments or changes in technology. This is why the project is a project on digital assets and is intended to be completely technologically agnostic. As such, any references, even in the commentary, to specific types of products on the market right now are only for the purpose of helping the reader understand the types of transactions that are being referred to, rather than pointing towards technologies that would be that would only be the subject of application of the principles. So let's get into the principles themselves. And before I do this, I'd like to importantly point out that all of the draft principles that I will be reading out and talking to you about in this presentation are only accurate as of right now. As I noted, this project is still ongoing, and the intention is to finish the project sometime next year. As such, the drafting committee and the working group might adjust these principles as it decides to do so. However, a lot of this work has already been completed, and it's very likely the principles that I will read out right now will, at least in some form or shape, be the final black letter rules that will come out as a result of this project. So in these principles, section 1 deals with scope and definitions, and principle 1 sets out the scope of the project. Principle 1 states that these principles deal with the private law relating to digital assets. This is incredibly important as it very clearly identifies the area of the law that these principles apply to. And in the commentary, it is further explained these are not meant to be regulations or regulatory in nature, but rather provide principles for private law that states should keep in mind when developing domestic legislation. Before the section on scope and definitions, there's also a section for the introduction of the principles, which guides readers and legislators to understand what the principles actually talk about and how they can be used and implemented within national legislation. Principle 2 in section 1 relates to definitions. This is where the definition of what digital asset is put forward. According to this, a digital asset means an electronic record which is capable of being subject to control. The principles also define what an electronic record is, which is an electronic record means information which is 1, stored in an electronic medium, and 2, capable of being retrieved. Then the principles go on to define what is principles law and what is other law, so as to offer guidance to states on what is covered within these principles and how to treat things that are not covered within these principles, which is that other law means the state's law to the extent is not principles law, whereas principles law means any part of the state's law which falls within the scope of the principles. Principle 3 in section 1 deals with some general principles that were important to be identified and outlined at the outset. Principle 3.1 sets out that digital assets can be the subject of proprietary rights. So over the course of the past few years, since digital assets have become more and more mainstream and more financial transactions are being conducted based on digital assets, this question has come up a lot in various different courtrooms. And so these principles seek to offer guidance on this issue, whereby they very clearly state that digital assets can indeed be the subject of proprietary rights. Principle 3.2 states that principles law takes precedence over other law to the extent that they conflict. After this, we have Principle 3.3, which points out certain things that are not covered by these principles. So Principle 3.3 states that except as displaced by these principles, other law applies to all issues, including whether a person has a proprietary right in a digital asset, whether a proprietary right in a digital asset has been validly transferred to another person, whether a security right in a digital asset has been validly created, the rights as between a transferor and transferee of a digital asset, the rights as between a grantor of a security right in a digital asset and the relevant secured creditor, the legal consequences of third-party effectiveness of a transfer of digital assets, the requirements for and legal consequences of third-party effectiveness of a security right in a digital asset. These things are generally covered by other law. These lists of exceptions and things that the principles don't apply to is continued in Principle 4, which relates to linked assets. Linked assets are assets that sometimes are off-chain assets or might be other digital assets that a particular asset is purported to have a link to or is somehow tethered to. For these, the principles very clearly state that other law applies to determine the existence of, requirements for, and legal effects of any link a digital asset in another asset, whether the other asset be tangible or intangible have. This is very important because sometimes there are a lot of confusions with regard to how an asset is linked to another asset. So examples of this include things such as real estate tokens that represent real estate, sometimes non-fungible tokens that are connected to real-world pieces of art, or tokens that have other implications which are not the subject of these principles. These principles apply purely to the digital asset in question. So for example, if there's an ERC20 token on the Ethereum blockchain, these principles will apply to the token itself. But if that ERC20 token purports to create rights in, let's say, a piece of real estate, that purported right will not be governed, or will not be determined, or the validity of that right will not be determined by anything in these principles. That's a matter for other law to determine. The principles continue, and this is probably a section which is very useful for the audience at this conference. Principle 5 talks about conflicts of law. This principle has been the subject of a significant amount of deliberation by the working group, and is still a work in progress. At the same time, we've also welcomed input from the Hague Conference on Private International Law for the development of this principle, and we look forward to continuing to work with the HCCH in moving this principle forward. So, Principle 5 on conflicts of law states that, subject to paragraph 2, proprietary issues in respect of a digital asset are governed by A, the domestic law of the state, excluding the state's conflicts of law rules expressly specified in the digital asset as the law applicable to such issues. This specification could be in the form of a white paper, a terms of reference document for a digital asset, and in other material. Part B, if paragraph A does not apply, the domestic law of the state, excluding that state's conflicts of law rules, expressly specified in the system or platform on which the digital asset is recorded as the law applicable to such issues. This could be a blockchain within which a token is based, for example. If neither paragraph A nor B apply, then these principles, and to the extent not addressed by these principles, law applicable by virtue of the rules of private international law of the forum. Principle 5 continues to say that in the interpretation and application of paragraph 1, regard is to be had to the following. Part A, proprietary issues in respect of digital assets, and in particular their acquisition and disposition, are always a matter of law. B, in determining whether the applicable law is specified in the digital asset or in a system or platform on which the digital asset is recorded, consideration should be given to records attached to or associated with the digital asset or the system or platform if such records are readily available for review by persons dealing with the relevant digital asset. C, by disposing of, acquiring, or otherwise dealing with the digital asset, a person is deemed to consent to the law applicable under paragraph 1A and B. D, unless an express specification of the applicable law or the applicable rules of private international law otherwise provide, the law applicable under paragraph 1 applies to all digital assets of the same description from the time that a digital asset is first issued or created. And 2E, if a digital asset or the system or platform on which the digital asset is recorded expressly specifies the applicable law effective from a time after the time that the digital asset is first issued or created, rights and interests in the digital asset that are established before that express specification become effective are not affected by the specification. These are all important rules for conflicts of law, and the commentary to the principles greatly explains these in details what they relate to. Paragraph 3 of Principle 5 states that notwithstanding the opening of an insolvency proceeding and subject to paragraph 4, the law applicable in accordance with the principle governs all proprietary aspects in respect of digital assets with regard to any event that has occurred before the opening of that insolvency proceeding. Finally, paragraph 5, Principle 5.4 states that paragraph 3 does not affect the application of any substantive or procedural rule of law applicable by virtue of an insolvency proceeding, such as any rule relating to A, the ranking of categories of claims, B, the avoidance of a transaction as a preference or a transfer in fraud of creditors, or C, the enforcement of rights or to property that is under the control or supervision of the insolvency administrator. These are all important considerations to keep in mind, and it's important to see the way that the waterfall described in Principle 5.1 operates, as this is where guidance can be sought on conflicts of law issues that arise in transactions and disputes related to digital assets. Now, as you could have already probably seen, the definition of a digital asset, as well as various other things inside this document, depend upon control. And so section 6, principle 6 of the digital assets principles defines what control is as per this document. In this, it is very clearly said that a person has control of a digital asset if A, subject to paragraph 2 and 3, the digital asset or the relevant protocol or system confers on that person, 1A1, the exclusive ability to change the control of the digital asset to another person. 2, the exclusive ability to prevent others from obtaining substantially all the benefits from the digital asset. And 3, the ability to obtain substantially all the benefit from the digital asset. And paragraph 1B, the digital asset or its associated records allow that person to identify itself as having the abilities set out in paragraph 1A. This then goes on to part 2 and part 3, which talk about a change of control and dig more into the exclusive nature of control, which is described in paragraph 1. So paragraph 2 reads, a change of control includes the replacement, modification, destruction, or cancellation or elimination of a digital asset and the resulting and corresponding derivative creation of a new digital asset, which is subject to control of another person. This is common industry practice, whereby when you transfer a digital asset to another person or send it, sometimes the original asset is destroyed and a new one is created in their wallet. So this reflects what the industry practice is right now. And then part 3 says that an ability for the purposes of paragraph 1A need not be exclusive if and to the extent that A, the digital asset or the relevant protocol or system limits the use or is programmed to make changes to the digital asset, including a change or loss of control of the digital asset, or if the person in control has agreed, consented, or acquiesced in sharing that ability with more than one person. So this generally describes the multi-signature arrangements that often exist. The commentary to Principle 6 also describes many of the common ways that digital assets might be the subject of control and provides what is considered control under these principles and what is not. So it uses examples such as using common exchanges such as Coinbase and Binance, as well as hardware wallets such as the Ledger wallet. And in other examples that might be very relevant for the reader to understand what this is referring to. Principle 7 in section 3 then goes on to talk about the identification of the person in control of a digital asset and where the burden of proof lies in doing this. Section 4 moves on to looking at transfer of digital assets. In particular, Principle 8 talks about acquisition and disposition of digital assets and says that in 8.1, the transfer of a digital asset is the change of a proprietary right from one person to another person. And 2, a transfer of a digital asset includes the replacement, modification, destruction, cancellation, or elimination of a digital asset and the resulting and corresponding derivative creation and acquisition of the resulting digital asset. So again, reflecting on the way this mechanism works in practice. Section 4 also has principles on things including the innocent acquisition of digital assets, the shelter principle, as well as the application of innocent acquisition rules to custody relationships, all of which are very important issues of private law that needed to be addressed in this instrument and are done so accordingly. Then section 5 of the principles on digital assets in private law digs into the issue of custody, which is very important and very commonly practiced in the world of digital assets. This This outlines that this section applies to where in the course of a business and pursuant to an agreement, a person, which is here referred to as a custodian, holds a digital asset on behalf of a client in a manner that the digital asset is held is not available to the creditors of the custodian if the custodian enters into an insolvency proceeding. The agreement between the custodian and the client, this sort of agreement, is called a custody agreement. This section describes the nature of the custody agreement and how that custodian has to hold a relationship between the custodian and its client. This section also talks about the agreement for services to a client and how this agreement impacts the rights of parties to third parties in the insolvency of a custodian. As such, if a custodian is holding assets on behalf of a client, then those assets generally do not form part of its estate in its insolvency, and this principle describes this in great detail. This can be found in Principle 13, 14, and 15 that all deal with this issue. Then, Section 6 of the Digital Assets Principles deals with secure transactions. Secure transactions has Principle 16, which is general, again, restating that digital assets can be the subject of security rights and describing how these operate in digital assets. So 16.2 says that if a digital asset is linked to a digital asset within these principles, as well as things such as using control as a method of achieving third-party effectiveness of a security right in digital assets, priority of security rights in digital assets, as well as some guidance on the effective enforcement of security rights in digital assets. Then Section 7 and Section 8 deal with issues relating to enforcement. This section, while it's still a work in progress, recognizes that enforcement in digital assets works mostly as it would in other assets. However, there are lots of practical challenges that need to be addressed, and guidance will be offered in the principles on some of these practical challenges that exist, particularly in the commentary. Finally, Section 8 on insolvency talks about the effect of insolvency on proprietary and security rights in digital assets and provides details on how these should be treated. To conclude, moving forward, these principles will continue to be developed at the working group, the 7th meeting for which takes place in December 2022. The working group will also continue to work on the refinement of the commentary in coordination with the drafting committee, which is continuing its work as we speak. There will be further work with the steering committee, as well as a wide industry and public consultation before the document is finalized, which is expected to take place in the middle of next year. So with that, I'll stop there. I'd like to thank the Hague Conference in Private International Law and the HCCH again for their kind invitation to UNIDROIT to present our project at this conference. We are very much open to questions and comments. I would ask you to reach out to me if necessary on Twitter or LinkedIn or even via email, and I'd love to answer any questions that anyone has on this matter. So thank you very much, and I wish you all a successful conference. Bye.